Alan, can you hear me? Say something because I don't think I have any sound.
I can hear you. Can you hear me now?
I sure can.
Okay, thank you.
We go all day? Okay, I didn't consider.
Good morning, everybody. How you guys doing this morning? For those of you that I haven't met, my name is Alan Nas. I'm your friendly neighborhood civil rights coordinator. Kind of like Jake from State Farm, but not nearly as popular or cool. Thank you today for taking your time out to be here. I appreciate this. Thank you to Mr. Brandon Carey for coming out to give us this training. As I've told you guys in emails, I've talked with Brandon and we set it up, and this is going to be more focused for tech centers since we are lucky enough to deal with secondary and post-secondary students. We have the chat open at any time. If you have any questions, please feel free to put them in there. Brandon will answer them as they come up. And for those of you that haven't gone through this training, it looks like a lot of power slides, but they go pretty quickly. I mean, I actually stayed awake the first time, so it was good. Thank you very much, and not to delay this any longer, I'll turn it over to Brandon, and thank you again.
All right.
And again, I'm sorry, we are recording this, and once we get done, and I can have our IT guys figure out how to put it up onto our website. Well, they know how to do it, I don't. So we'll get it up there as soon as we can, and I will let you know when it's up there. Thank you.
All right. You're going to see me in two of these boxes because I'm also using Alan's computer to look at the PowerPoint. But it's good to be here. Again, my name's Brandon Carey. I'm an attorney with the Oklahoma State School Boards Association. And obviously we're a nonprofit that serves school districts across the state, and career techs are one of the types of institutions we serve. I'm kind of, I help run our employment program, but I'm also our Title IX person. I actually did a lot of Title IX work with the U.S. Department of Education when I was an attorney for them. And I was then the general counsel at Oklahoma City Public Schools and did Title IX work there. And I do it here for OSSBA, trying to train everybody on these new requirements. And the new requirements are extensive. They're in some ways good and in some ways onerous and tough to understand. But we got to figure out how to do it. So that's what I'm here to try to help you with. And I'm actually gonna grab something here. So a few ground rules. Never hesitate to ask a question. I don't care what point of the conversation we're in. I don't want to move along if you're still confused. The point of this is for you to get a better understanding of your obligations under Title IX. So don't hesitate to, and Alan, in what methods are they able to ask questions? The attendees virtually?
They can ask verbally. Or
they can unmute and ask verbally, or you can put it in the chat. And we have a few people actually here present. Do not hesitate to get my attention and let me know you have a question, because that's important. And I can stay after to answer questions as well. So let's go ahead and get started. I've done quite a bit of, done some research. I've spoken to some different people. Oklahoma's, I almost said OU's, and Stillwater is the wrong place to say that. Oklahoma's career tech system is somewhat unique across the country, I think, with regard to how extensively it serves K-12 and the innovative ways that it does so. That actually creates a really odd dynamic with these new regulations, that these regulations do not take into account. So I've spoken to people with Oklahoma Career Tech, Corey Gray, I believe, and others. And I've also spoken to people that are sort of known as some of my friends that are national experts to kind of get a better understanding of when the higher ed rules will apply, because there's some slight differences, and when the K-12 rules will apply. And it's probably going to be a different answer than what, if you've attended any of my other workshops, I may be giving you a little bit different, more complicated, more nuanced answer this time. So let's get into that. I put this first slide up here just to give you some context. We're not going to get too deep into it, but when you look at case law, when you are looking at if somebody files a lawsuit and takes you to federal court because of a Title IX issue, they determine liability according to a three-part test that was first spelled out by the Supreme Court in the case Gebser v. Lago Vista Independent School District, and this was 1998. And that test is, did an official of the educational institution have actual knowledge of the harassment? Did they actually know? Did the official that knew about it have the authority to institute corrective measures to resolve the harassment problem? And if those two are satisfied, then did they then fail to adequately respond to what they knew to such an extent they acted with quote unquote deliberate indifference or unreasonable in light of the known circumstances? An official with authority to institute corrective measures in a career tech setting in case law, in my opinion, would be like a director, an assistant director, or a higher level administrator, not just a normal instructor or an administrative assistant or something like that. I think it would have to be a director, an assistant director, or somebody a little bit higher. Now that is your case law, federal case law liability standard that has been the standard for over 20 years. And I want you to remember that because OCR is now mirroring that a little bit more, and we'll speak about it as we get further into this. So the new Title IX regulations, they were released on May 6, 2020, and they gave us a good amount of time there, less than 4 months to come into total compliance. I think some of that shortened timeline had a little bit to do with just unknowns about the election, making sure everybody was, that OCR had everybody complying with them before the elections came up. Because, you never know what's going to happen in an election. What do these new regulations do? Several things. But I mean, they really fundamentally alter some of the core aspects of Title IX compliance for educational institutions, including how OCR determines whether an institution has notice of sexual harassment. That case law standard I just spoke to you about has not been OCR standard. OCR standard has been a lot stricter for quite some time. So you could be not liable under federal case law and because you didn't have notice, but found to have had notice and be liable in an OCR investigation previously. The amount of due process required to be provided to the parties has changed significantly in these new regulations. Step to take during an investigation, etc. And they've also revamped the definition of sexual harassment. And that's where we're basically going to start here with rolling up our sleeves and getting into it. So the new definition of sexual harassment, and you'll see on this PowerPoint, I've tried to add the federal regulation citation for everything that I'm giving you. Not that you'll necessarily go specifically and look it up, but you might if you need if you need to prove it to somebody or to yourself. So what is this new definition? Sexual harassment means conduct on the basis of sex that satisfies one or more of the following. Quid pro quo. That has not changed. Okay, that's still the same. An employee of the recipient conditioning the provision of an aid, benefit, or service of the recipient on an individual's participation in unwelcome sexual conduct. In normal language, an employee saying, if you want this, you have to engage in this sexual act, or you have to do whatever in a sexual manner. That's quid pro quo. This for that is the Latin. So that's one of the easiest to understand. You want a better grade, you have to engage in a sexual relationship with me. Something like that. Secondly is hostile environment. This hasn't changed too much, but I'll talk to you a little bit about how it has. Unwelcome conduct determined by a reasonable person. The reasonable person standard wasn't in there previously. Reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the recipient's education program or activity. So let's break that down a little bit before we go to the third definition of sexual harassment. So it's got to be severe. Well, what does severe mean? It could be non-consensual sexual contact, even though that is also now just per se sexual harassment in the third part of the definition that we will come to. It's got to be more egregious, definite sexual overtones, something that would definitely make somebody feel uncomfortable. The more severe, the less need to show several incidents. But what I will say is the way the new definition is written, it seems to be saying that if it's going to be a hostile environment, it has to be severe and pervasive, which is this next slide that we're talking about here. It occurs in regularity or in concert with other things. There's a pattern and practice. It's widespread. It's well known. It's occurring in public places. So the new definition of hostile environment, somewhat revised, seems to indicate that not only does it have to be severe, but it has to be pervasive as well. It doesn't say or pervasive. It says pervasive, it says severe, comma, pervasive, comma, and objectively offensive, which basically grammatically means all those are an and. So it has to be severe and pervasive. Well, people mostly will ask, well, you're telling me a sexual assault has to happen more than once? No, because that's now the third part of the definition that we're getting to. But anything that is not a sexual assault, anything below that, comments, text messages, social media posts, things you might do, signals you may give with your body, inappropriate motions, things of that will have to be severe and persistent or pervasive. And it has to be objectively offensive. It means that anybody would say that was offensive, is what that means. And there are several things you look at there to determine that, but it really is a common sense approach. If I'm a student and I walk up to another student and say, I think you're attractive, I would like to go on a date with you. And the student said, and the person I'm talking to says that's inappropriate and that's sexual harassment. I don't know that it may not be the most normal way to approach somebody, but just calling somebody attractive and saying you want to go on a date isn't offensive to everybody. That's not something that's objectively offensive. However, if I walked up to him and said, I want to have sex with you in the restroom now, I would say, most people would say that's an offensive thing to say. If it was unwelcome and there's no history between those people, I would say that's probably easy to say that that's offensive. Now, is one incident of that going to be hostile environment? Probably not, because they say severe and pervasive. But 3 of those might be. You'll have to look at it to make an individual case-by-case decision. Make sure to consider all the relevant circumstances when looking at hostile environment. The degree to which the conduct affected one or more students' education, the type, frequency, and duration of the conduct, or relationship between the individuals, the number of individuals involved, etc. And then it says that, and let's go back to it real quick just so I can read it. It says that it effectively denies a person equal access to the recipient's education program or activity. So, if it is severe, persistent, and pervasive, severe, pervasive, and objectively offensive, then it is also supposed to effectively deny them access to your educational programs and activities. If it's severe, persistent, I keep saying persistent, that's really the old one. Severe, pervasive, and objectively offensive, it's going to deny them equal access. That is not, that does not have to be severe consequences educationally, but things to look for in that. Are they skipping class to avoid a harasser? Is there a decline in their grades? Are they having difficulty concentrating in class? Are they just really uncomfortable in class to the extent that class does not feel, or the school does not feel like a safe place for them? That's basically what that means. This is important. On the next slide, no concrete injury is required to conclude that serious harassment would deprive a reasonable person of access to the recipient's education program or activity. You don't have to show so this thing is specifically happening. As long as this bad thing is specifically happening, as long as there's evidence they're not comfortable. A little bit of a noise coming from the computer, so if you guys hear it, let us know. It's not bothering me too much, but if it's bothering you, yep, they hear it. I wonder if I sit back a little bit. I don't know. You know what it is? Well, no, your computer's on mute. Mm-hmm. Is it still coming through, the feedback? I'm wondering if we need to pull the camera out just a bit. Better now, they're saying. Fixed, much better. Okay. It may have been that I was too close.
Brandon, I've got a question.
Yes.
If it's okay to ask you a question right now.
Yes, it is.
Look at this definition of hostile environment and breaking that down. Let's just say there's an issue that did not meet the criteria of hostile environment related to sexual harassment. Should we still run that through, potentially through our bullying policy if it violated our bullying standards?
Fantastic question, and the answer is yes. So the question is, yeah, I hear it a little bit here. Let us know if you're still hearing it. It may just be us hearing it now. The question is, and we're actually going to get into that. But let's go ahead and give them a preview. If something doesn't meet the definition of sexual harassment, is there a possibility that you will run it through other policies, such as your bullying standard or just your regular student code of conduct, inappropriate conduct? Absolutely, there is. And we're going to get into that a little bit deeper here in just a while. So that's a good preview. Okay, the third definition of sexual harassment is if the conduct constitutes sexual assault, dating violence, domestic violence, or stalking. So it's kind of interesting in that they just took a mishmash of things and threw them into this third definition. But it also, the more I was looking at it, it matches with your your reporting requirements under the Clery Act. Those are instances that you have to document and report under the Clery Act. So if it is one of these, remember, or if one of your Clery Act people are documenting some type of conduct, you might want to make sure it's not also sexual harassment. So let's talk about these. Sexual assault is exactly what we think it is. An offense that meets the definition of rape, fondling, incest, or statutory rape. So it's one of those. Domestic violence. A felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner, a person with whom the victim shares a child, a person who is cohabitating with or has cohabitated with the victim, etc. Now, domestic violence, one of the questions I think I received, and I didn't bring it for some reason. One of the questions, let me see if I did bring it. I got a list of questions from Alan, having a bad morning, that were from you all. Did bring it. And one of them was, if I can find it here, dating violence, domestic violence, and stalking are mentioned as sexual harassment, but we aren't sure how some of those issues relate to school or school-related activity. It's a fantastic question. Well, how do they? Domestic violence doesn't have to be in the house. Domestic violence can be one of these spouses or partners engaging in that violence on campus. Now, the odd thing is it's not necessarily saying that it's sex related, but I guess because they have some type of intimate relationship, they're including it in that. So you could have the one student who has a child with another student, and if violence occurs between them on campus, you'll have to look at your sexual harassment possibilities. If one individual spouse, if a student is married to another student and there's violence between them on campus, things of that nature. If one student is living with another student and there's violence between them on campus.
Brandon,
Yes.
speaking kind of on the same thread, let's just say the victim is a student on our campus, the perpetrator is not on our campus. What limits of responsibilities do we have to that current student to make sure they're protected?
So the question is, what if perpetrator, you said, is not on campus? Yeah, student is obviously on campus, perpetrator is not. What responsibilities do you have? We're going to get into that, but let me just say, when we get a preview is, it depends on, number one, where it occurred, is almost going to be the main factor in that. Did it occur on campus or at a school activity? Secondly, we're going to talk about supportive measures, which you can provide at any time you feel it's appropriate, and there are sometimes you have to provide it. So those two things we're going to look at. But where it occurred is going to be really important for that. Good question. Dating violence. Violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. So dating violence is sexual harassment now. Now, this all assumes that you have jurisdiction over these acts. We'll talk about jurisdiction here in a little while. This is just the definition of sexual harassment. And stalking. Engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for the person's safety or to the safety of others, or the safety of others, or suffer substantial emotional distress. So those four things are in the definition, the third definition of sexual harassment. And like I say, they also mirror some of your reporting requirements under the Clery Act, which career techs have and post-secondary institutions have, that does not apply to K-12. So that's an important thing to think about.
Where's this bathroom lighting?
Working on the noise again, sorry.
Is that any better?
So how about now? Tell me if you still hear it.
I apologize. I'm going to call our IT guy, see if he can come help us.
And what about, see if you pull this computer away. That may have something to do with it. Does it get better when the computer is further away from me?
Are they all muted?
Yeah, and make sure everybody is muted.
Is it still there?
Not hearing it now.
What about now? Can you still hear it now when we're talking?
So I'll continue until you hear it. I have a feeling that computer may have been too close to me. It's better. I think that computer is a little close to me, which
Is
we
it still
can
better?
pull it even further away if we need to.
Okay. Well,
Okay.
can you try talking real quick?
Sure. How do I sound now? Is it better or is
Right
it
now, it's not making any
worse?
feedback even when he talks. Okay, we move the computer back and then.
I think that's
if
what it
it comes
is.
back again, just text me, let me know. All right, thanks, brother. Bye.
If you want to pull that maybe on this side, because I think I've developed something where I don't need it as close. Perfect. Okay. It starts again, let us know.
It's back.
Well, we were just moving the computer. What about now? Yeah. And someone said good. All right, I'm going to try going for a while, and if it's still a problem, we'll figure it out. So let's talk about institutional notice, supportive measures, and complaints. How does an institution have notice under OCR's regulations now of sexual harassment? By that, when is OCR going to consider you to have had notice? Previously, they said you either had, if an employee committed the conduct, you had constructive notice, which means you were basically vicariously liable. If it was anybody else committing the conduct, it was, did you know or should you have reasonably known was the standard. Well, that's not the standard anymore. They have basically adopted the Supreme Court standard for career techs for post-secondary institutions. The case law standard of actual notice will be the standard for OCR complaints as well. In the regulations, they actually call it actual knowledge. There's no more constructive notice if it's an employee. There is no more should you have reasonably known if it is a third party or student engaging in the conduct. It is now actual knowledge, which means you have notice of sexual harassment, your institution, if it is known by the Title IX coordinator or is known by an official who has authority to institute corrective measures on behalf of the recipient. Again, I believe that is a director or assistant director level position for career techs. K-12s are different, just to let you know, because some of your courses are offered on K-12 campuses. And we're going to get into that difference in a minute.
Yeah, we call it on or camp.
And yes, they are. Yes. And we're going to get into that as well. I'm just trying to, maybe this might be a good time to do it. But for K-12, it's any employee that has notice. Then the district has notice.
Your next slide.
So this is, yeah, I saw it. This is a good point to start kind of talking about the unique circumstances that career techs find themselves in with these laws. That was interesting. That's a perfect text for Halloween season. Yeah. So the regulations don't really say that you're obligated to adhere to one over the other based on the student. They talk about obligated to adhere to either the higher ed rules or the K-12 rules based on the institution. Now, under the definition in the regulations, career techs are defined as a post-secondary institution, and there just aren't, I feel strongly that OCR did not consider any of this when developing these regulations. They didn't have an institution like our career tech system in mind. They just didn't. So when are we supposed to follow one set of rules over the other? They're only different in a few circumstances. One is when you have notice, and one is whether you have a hearing or not, basically. So when are they going to be different? For Oklahoma career techs, I believe if you are offering a course on a high school campus, it's my understanding the students would be subject to the disciplinary rules of that campus, the high school campus at that time. Those are the K-12 rules. If you are offering the course on campus and it is only K-12 students, sometimes it's my understanding if there's disciplinary issues, they may be referred to their high school. Sometimes the career tech takes care of it. It just depends. I think if it's being offered on campus, the safest way to do it, because OCR doesn't seem to understand the difference, is to adhere to the higher ed rules. That's the only thing I can really do. I think it makes sense to adhere to the K-12 rules. I do. Do I think OCR is going to understand the difference? I used to work there. I know how they are. I don't. That's my fear. So go ahead.
So what I'm hearing is that any K-12 student that is taking a course at which is my school, Pioneer Technology Center, if we do find it's a Title IX complaint, then we need to provide the hearing as part of that.
I think so, unless you just refer those issues to the high school and they take care of it. If it is the career tech doing the Title IX investigation.
And typically, it is us doing the investigation because we've got, let's say,
Yeah.
two K-12 students from different partner high schools,
Mhm.
so there's no way to
Absolutely.
work together to collaborate.
I don't know how. I would rather you have to follow the K-12 rules. The more I've looked in it, the more I've researched it, the people I've spoken to, the less confident I am that OCR would look at it and say that you should have been following the K-12 rules when the allegation occurred on the career tech campus and the career tech is investigating it. That's not what I want to tell you, but I feel like it's what I have to tell you to make sure that you're being protected from these rules. Yeah, it's frustrating.
My program is strictly K-12.
Your program is all K-12.
Yeah. It's,
Well, there may be some difference there if you don't have any adult students.
in my classroom. They go to another program that does have no,
Oh, you mean another program on campus?
on my campus.
Yeah.
I do, the sheriff program, we do, there are four and some electives. Then they go to the other course, to their tech class, to get their electives.
Right.
The students on campus all day.
Yeah, and the students are on campus all day.
All day. And then half the day with the other class.
Is it, but it counts as, why wouldn't they ever be in their feeder high school? Mm-hmm. Yeah. Unfortunately, see, in my opinion, it would make sense to do the K-12 rules. I just don't think OCR is going to look at it that way. I think they're going to look at it and say, that's a career tech, which meets the definition of a post-secondary institution, which means they have to do the hearing. I just, if I could find a way to say it's not, I'd do it. But I'm just, the more I've researched it and the more people I've spoken to, I'm just not comfortable with it.
It actually clarifies things for me,
People can't hear
because
the
we were
questions.
wondering what we would do in a situation where it's an adult student harassing a high school
Yes.
student or vice versa. Do we offer the hearing? Do we not offer the hearing? You know,
Right.
If we offer the hearing for everybody, then that clarifies that.
Right. Yes. So one of the questions was, well, and really it was more of just a point, which is, my program is just K-12. They're with me half a day on campus, and then they go to they may go to another program on campus the rest of the day with adult students. And that's what they do the full day. And in my opinion, it would be easier and make sense to apply the K-12 rules. However, I just don't believe OCR is going to look at it that way. I think that if the more research I've done, if it is offered on campus and it is the career tech investigating and instituting the discipline, I do not believe that OCR is going to look at it and say, well, since you have K-12 people, we're going to go ahead and let you follow the K-12. I think they're going to say you're a post-secondary institution. You have to follow the post-secondary rules. And one reason I say that is because I've worked there and I know that they're not interested in looking at that difference, unfortunately. Even though it does make it an easier decision with regard to, you know, if one student's an adult and one's K-12, et cetera. Now, if the program is offered on the K-12 campus, I believe the K-12 rules are to be followed. And really, the difference we're talking about is whether you have a hearing or not. That's a difference.
How about notice?
Well,
Can you repeat the question?
yeah, the question was, how about notice? When it's a career tech, I believe you will be held to the career tech notice, which is an assistant director or higher level administrator. I also strongly suggest you train all your employees to report anything they've noticed. Yeah. So let's say that actual notice has occurred. What's the first thing you have to do? First thing you have to do is the Title IX coordinator must be notified. If the Title IX coordinator was not the person that received notice, they must immediately be notified. And then the Title IX coordinator actually has to contact the complainant. And it's important to understand under the new regulations, the complainant is not only the person the complainant is the victim, whether they're the one that complained or not, that made the allegation or not. The complainant is considered the alleged victim. Title IX coordinator must contact the alleged victim, explain how to file a formal Title IX complaint if they want to do so, and offer supportive measures, which we used to call interim measures, which are things that keep them safe or make sure that everybody is safe pending the investigation. And we will talk a little bit about those now. What is a supportive measure? Must be offered upon actual notice, used to be called interim measures. It may be offered during or in lieu of a formal complaint if somebody does not want to file a formal complaint. It is to restore or preserve access to the program without unreasonably burdening the other party, which means it could be access, it could be a stay-away agreement between the parties on a career tech campus where there are adults. It could be, you know, we're going to offer you some escort services for the next few days with our campus security. It could just be we're going to have increased monitoring. It could be we are, for K-12 students, we're going to separate you in class, things of that nature. We're going to give you access to a counselor to talk to the counselor pending the investigation, things of that nature. So the first thing upon actual notice that you must do is your Title IX coordinator must contact the alleged victim, explain how to file a formal complaint, and offer supportive measures. Now, why explain how to file a formal complaint? Because you will no longer be obligated to investigate something under Title IX unless a formal complaint is filed. So what is a formal complaint? It's there under 106.30A in the regulations. It is a written document signed by either the complainant's parents, if they're a minor, or the Title IX coordinator, alleging sexual harassment against a respondent, against a specific individual. Respondent is the person alleged to have the alleged perpetrator, and requesting an investigation. A formal complaint may be filed with the Title IX coordinator in person by handing them the written complaint or filling it out, by mail, by email, or any other method that career techs design that allows them to file a written complaint. So when you call and explain how to file a formal complaint, I think it's smart that you also say, if you file a formal complaint, we will investigate it under Title IX. If you don't, there are two options. Well, there are three. One is that the Title IX coordinator will file one, and we'll talk about when that's appropriate, not often. Number two, we'll investigate this under other policies, such as our general harassment policy, our bullying policy, our just normal inappropriate conduct, student code of conduct. Or number three, what you've told me doesn't allege anything and we won't investigate it. Yes, the Title IX coordinator may file a formal complaint on behalf of an alleged victim when the Title IX coordinator determines that a non-deliberately indifferent response requires an investigation. What's an example? An example might be an allegation of you have actual notice of a sexual assault that has occurred. An example might be, this is the third complaint from a different person I've received about this individual. Something's going on. The rules also say if a grievance process is initiated against the wishes of the complainant, which means they say, I don't want to file a complaint, and the Title IX coordinator determines that they're going to, the decision should be reached thoughtfully and intentionally by the Title IX coordinator, not, and I've underlined this, this is straight from the lengthy final rules and commentary, not as an automatic result that occurs anytime a recipient has noticed that a complainant was allegedly victimized by sexual harassment. This isn't just, well, they're not going to file, so I'm going to file for them. This is, if I don't investigate this, I feel like it's completely unreasonable.
Brandon, can I
Yes.
ask you a question about the written notice, going back a couple slides?
Absolutely.
You said that on the slide that it has to be written, it can be mailed, it
Uh-huh.
has to be
Let's go
signed.
back to that.
There's a lot of schools that actually have online reporting for bullying, sexual
Yeah.
harassment. Is that considered a written notice since it's notification and the individual has their name on it?
So you notice that would give you actual notice that something has occurred.
What was the question?
But, oh, thanks. I keep forgetting to repeat the questions. My apologies. Don't hesitate to remind me. See, someone wrote noises back. Is the noise in there right now? I'll keep talking, but if it's still there, let us know. I'm not sure when that was written.
That was a while ago.
Oh, that's a while ago. So the question is, what if we have an online reporting mechanism for somebody to report bullying or harassment or whatever, and it has our name on it and says what happened? That definitely gives you actual knowledge that sexual harassment may have occurred, okay? However, a formal complaint requires not just a signed allegation that alleges sexual harassment against a specific person, but that requests an investigation. So my opinion is, unless that has all of those things, I would consider that actual notice. I would contact them, explain to them how to file a formal complaint and what's required, and give them the chance to either file one or not. Does that make sense?
Yes, we actually worked through one of those earlier this school year with that very scenario. And what we basically did the same thing that you recommended, and we're just trying to figure out the process ourselves.
Yeah.
The new policy.
Excellent. Yeah, I would, when it is a, campus-wide reporting system, I would consider that actual knowledge, and then you contact them and explain how to file a formal complaint. What if you have notice, but they don't want to file a complaint? As I said a minute ago, you might need to look at investigating under your other policies, or your general harassment or bullying policy. Your student code of conduct, just for inappropriate conduct. You may have to deal with it in another way. But if you don't have a formal complaint, and it's not one of those rare instances where the Title IX coordinator says, I have to file this formal complaint, then you're not investigating it under Title IX. That's one of the new things. Just remember about your law enforcement and DHS reports. Also, if the allegations constitute, when you have K-12 kids, if it constitutes abuse, you may need to contact DHS, or you would need to, and the police. For your adults 18 and over, if it constitutes a crime, you'll need to contact the police or abuse or campus police or local police or sheriff. Also remember your Clery Act reporting obligations. They may be, they may constitute the same thing, in that this allegation of sexual harassment also is something we have to list as a Clery Act thing and fill out our annual security report and things like that. Okay, so let's talk about applicability and jurisdiction. So you must have actual knowledge, and when you have actual knowledge, you have to take these steps that I've told you, and they must file a formal complaint. Well, then, once they file a formal complaint, you have to determine a couple of things. Do we have jurisdiction? And one limit on your jurisdiction now is that, said noise just came back, just popped up. So let us know if it gets any better or worse. The allegation must have occurred in an education program or activity of your institution and to a person in the U.S. Yeah, that they say Title IX is limited to only people in the U.S. That would just mean like if there were, and I don't think any of you are dealing with this, but if there was some study abroad program and it happened in a study abroad program, Title IX doesn't apply. It must be in the United States. So, what is the education program or activity? It includes locations, events, or circumstances over which the recipient, which is recipient is you, the institution. It means recipient of federal funding. The recipient exercises substantial control over both the respondent, remember that's the alleged perpetrator, and the context in which the harassment occurs. So what does that mean? Do I need to stop and wait? Basically, to investigate under Title IX, you must have jurisdiction over the subject matter, which means does this meet the definition of sexual harassment? Over the people, and over the place, event, or activity. Let's get further into that. Subject matter means does it meet one of the elements of sexual harassment? People, with regard to the complainant, they must be participating in your program or attempting to. What does that mean? Maybe they've withdrawn and would enroll if they weren't being harassed. If they're not participating in your program, you don't have jurisdiction under Title IX or attempting to. Yes. Try what? We're going to try something real quick.
Jeremy, can you hear me?
So far, that sounded good.
That sounded better.
Yep.
Do you still have the noise?
Nope.
All right. Thank you.
Yep.
I apologize, everybody. I thought we had this figured out. Hopefully.
So, maybe not. Yeah, it's coming through the speaker. Want me to wait or go? Okay. So, yeah, that's good. How about now? There we go. Okay. The respondent. Does the institution have substantial control over the respondent? Are they a student, an employee, a volunteer on campus, a contractor working on campus, something like that? If no, you don't have jurisdiction. The place or event. Does the institution have substantial control over the context in which the sexual harassment occurred? For example, did it occur on campus or during an online class? Off campus, but at a location owned or controlled by the institution. Maybe at a, an ag barn, which would be really considered campus, but a research place or a place that you're renting. Off campus, but a school-sponsored event. It's an event that we're having at a specific location. K-12, it's a field trip. If yes, then you have jurisdiction. If no, it's not Title IX. So let's talk about place or event a little bit more, because you're supposed to know a little bit more about that under the new training. If the harassment occurred on campus or at a school-owned or rented facility, you have jurisdiction. If it's off campus, you've got to look at the following. One, did it occur as part of your operations? Classes, online classes, work environments, extracurricular activity, computer and internet use. Or two, did you exercise substantial control over the respondent in context of the alleged harassment? Were you funding, promoting, or sponsoring an event that it occurred at? Was this an institution-sponsored trip? Was it at some type of a stock show that was part of school operations? Or, and this really doesn't apply to career text, but for post-secondary, it occurs at an off-campus building owned or controlled by fraternity or school. So we used to talk about the downstream effects. It happens off campus, but the downstream effects affect things on campus. Well, let's be clear. Unless it meets one of the things I just spoke about, you do not have jurisdiction to investigate. So if it happens allegedly happens between two students at a party on the weekend or at one of their houses, then you don't have jurisdiction. The only way you would look at anything related to that is if the behavior continued on campus. Whatever happened off campus or began off campus continues on campus or continues in another way on campus that constitutes sexual harassment. If it's not Title IX, again, you may be looking at it under other regulations. But you get the allegation, quick summary of where we are. You have actual knowledge, which is Title IX coordinator or assistant director. I strongly suggest you just do your best to adhere to any employee that has notice needs to tell you. Title IX coordinator must contact complainant, must explain how to file a formal complaint, must offer supportive measures. Those supportive measures, even if they don't file a formal complaint, you can offer the supportive measures, and it may be best that you do. If they file a formal complaint that meets all the requirements, then you have to determine whether it happened in your education program or activity and whether it meets the definition of sexual harassment and whether you have control over it. If you do, then you move on to the new grievance procedures under Title IX. If you don't, you investigate under something else. I think that's an important difference there. I think it's a very important difference. Not difference, that's not what I'm just kind of demarcation point. All of that, and all of that's really going to happen fast, all those decisions. It's not going to, it may happen quicker than the time I've been speaking. So once you've determined that you have a formal complaint and you have jurisdiction, then you have to start these grievance procedures. And this gets pretty onerous. No problem. These grievance procedures you see there at 106.45 of the regulations. If an institution follows these grievance procedures, it's what they call in the law a safe harbor. What does that mean? It means that if you follow these grievance procedures, OCR is not going to find that you acted with deliberate indifference. They will not. If you follow these procedures with fidelity, you have done what you are supposed to do. There's a little flow chart. And flow charts are terrible because I don't really know how to do them. I'm not creative at all. But this is just a flow chart that kind of talks about, kind of mirrors what we're going to, is an overview of what we're going to get into now. So, the initial steps of the investigation. Overall, OCR says the following. Your grievance procedures must treat the complainant and respondent equitably. Whether it's whatever your opinion of it is, the facts are a lot of these new regulations are because are the result of complaints that Title IX investigations were biased against the respondent from the start. That's why they instituted a lot of these due process requirements. I'm not offering an opinion on that. I'm simply telling you that's the context behind some of these. So they want you to approach this with a neutral mindset, and both must be treated equitably, including providing supportive measures to both parties, or at least offering them. The Title IX coordinator, investigator, or person making the decision must be free of bias against the complainant or respondent, and appropriately trained. And you must have reasonably prompt timeframes for the completion of the investigation. Now, you have to be trained in bias and conflicts of interest. I'm about to record a video for that. It will be on the website. And then you can use that to show that you've had that training as well. So let's talk about notice to parties. You have something you're going to investigate. Previously, what did we do? Well, we probably initially told them verbally and may have even interviewed them, and then maybe followed up with a written notice with the allegations, depending on how we did it, because we were left quite a bit of leeway previously. Well, that's not the case anymore. You must provide written notice to both parties, and by that I mean the respondent and complainant. And there may be more than one respondent or complainant, it just depends. Written notice to both parties prior to any discussions or interviews, excepting the discussion where you call the complainant and explain how to file a formal complaint and offer support measures. And provide them sufficient time to prepare a response. What must be in that written notice? A lot of things. We have two different written notices on our website. One is under our policies, which is just kind of the standard written notice form. Two is a form I've developed that's on the Title IX forum on the OSSBA website that's a little bit more in-depth. Use either one for fun. Citations to relevant grievance procedures must be in this formal notice. Allegations with sufficient details. A statement indicating the responding party is presumed not responsible until a determination is made. Notice that parties may request to inspect and review relevant evidence, and a reminder of the institution's policy not to make false statements, intentionally submit false information. It's got a question. It's behind the blue box. Does the coordinator provide notice or the investigator? That's a fantastic question. It is just fine for the investigator to do it if the investigator is not the coordinator. Title IX coordinators can be the investigator. But if the Title IX coordinator is not investigating, then the investigator can provide this. Either is fine. Either is fine. It's however you feel is most efficient. You must also provide written notice to the parties when there's any reasonable delay for good cause, and we'll talk about what that could be. or any additional allegations are added that weren't in the original complaint, such as you had an interview with the complainant and got more information. Time frames. Well, the old standard was OCR provided a 60-day time frame for completing the whole thing. With these new allegations, that's going to be hard to meet a lot of times. I mean, new regulations, that's going to be hard to meet a lot of times. So there's not a 60-day time frame anymore. They say must include reasonably prompt time frames for conclusion of the grievance process. And you must do everything in a reasonably prompt manner. So as soon as you can, I suggest setting up your own time frames. And maybe you can meet those 60-day guidelines. But it needs to be somewhat as prompt as it can be under the circumstances. And then your standard of proof. I don't know how many of you really remember what that is. That is, what do we judge this by? The standard of proof in a criminal court is beyond a reasonable doubt. We're not going to convict somebody unless we can prove it beyond a reasonable doubt. In civil court, it's generally clear and convincing evidence. Well, when it comes to investigating policies, violations, or Title IX violations, you are able to use either preponderance of the evidence or clear and convincing evidence. What's preponderance of the evidence? That's 50.1% of the evidence, more likely than not. 50.1% of the evidence points one way. Clear and convincing is substantially more likely than not. I compare it to like 75% of the evidence. However, it's important to understand that you can only use preponderance of the evidence as your standard if that is the evidence you use for other violations of the student code of conduct with the same possible consequences. So in K-12, really the biggest consequence, unless it's like a weapons thing, is suspension for the rest of the semester and the next. For your adult students, you'll have different consequences possible. You can only use preponderance of the evidence under Title IX if you use that as your standard for other things with the same possible consequence. Also, if you're going to use preponderance of the evidence for Title IX, that also must be what you use for investigations of employees for sexual harassment. So, if you use clear and convincing for either other violations with the same consequence or investigations of employees for sexual harassment, then you must use clear and convincing for Title. Basically, what they're working really hard to make sure, I think they're trying to encourage you to use clear and convincing, but you don't have to. It's up to you. Also, you've opened the investigation. You've provided written notice to the parties of the allegations. Every once in a while, we decide to suspend somebody pending investigation, or short-term suspend. Well, if you've opened the Title IX investigation, the only way to do that is what they call is to use an emergency removal. Before emergency removal of a student, the institution must perform an individualized risk analysis, determine that immediate threat to the health or safety of students or employees justifies removal, and provide the respondent with notice and an opportunity to challenge the decision immediately following removal. I think that could be a written change. But if you're investigating under Title IX and you want to short-term suspend one of the students pending investigation, you have to be able to say that they're an immediate threat, they're possibly an immediate threat to students or employees, and give them notice of this and the opportunity to challenge it.
timeline. And that's really,
Yes, so the question is, let's say there's an allegation of sexual assault from the complainant, and you decide we need to emergency remove this respondent pending investigation. I actually have a form online that I think you can use that I've developed, which is just basically based on the allegation of, we've determined that you are an immediate threat to the health or safety of students or employees. You have a right to challenge this in writing to me by this date. And it doesn't mean you can go ahead and emergency remove them, but they need to be given the opportunity to file a written challenge within a day or two. And then you can read that written challenge and determine whether you're going to allow it or whether you're going to override your emergency removal. Generally, you're not going to, but that's what they want in there. They want that opportunity. It's not I would not call it a structured, really formal appeal process for this. I think the Title IX coordinator would make it. Who would make the decision on emergency removal? Let me rephrase that. I think the Title IX coordinator, in conjunction with your campus director or assistant director or whoever normally makes those decisions, would make the decision on emergency removal initially. And then I think they would probably appeal to the Title IX court, the emergency removal, which just in writing. And the Title IX coordinator can immediately say whether they agree with the emergency removal or not. But you would say that in writing, whether an email or a letter or whatever. There is also, and I'm developing a training for this. Not many people. There's no real guidance on it, so people are trying to figure it out still. There's also an option for informal resolution if institutions want to provide that. That is, at any point during an investigation, the institution and parties can determine if it's appropriate to bring the parties together or to mediate when they're separate, to determine whether there's some type of informal resolution that can be developed that does not require the finishing of the investigation. It must be voluntary. Both parties must consent in writing, and it cannot be used if the allegation is of an employee harassing a student. It cannot be used for that. For an informal resolution, you must provide detailed notice of the allegations, the requirements of the process, the circumstances which would preclude formal or informal resolution, and consequences of participation. Basically, you have to tell them, these are the allegations. This is how we do the process of an informal resolution. And if you participate in this, it means that you may not, we may not make a disciplinary decision because we've come up with something else through the informal resolution. They just need to understand the possible consequences. Also, at any time, I think that informal resolution, if it's clear one cannot, resolution cannot happen, that you stop it and continue the investigation. Okay. So let's go to during the investigation. We provided notice of the allegations, and we've made a decision, if necessary, on emergency removal. And if there's an informal resolution process that you offer, you've thought about whether that's appropriate. But you can think about that at any time during the process. And you don't have to offer informal resolutions. It's up to you. So what does OCR broadly state are the general principles during the investigation? The burden of gathering evidence is on the institution. So it is not acceptable to say, Well, I asked for that information, or it is not acceptable to say they didn't give me the information. You must actively attempt to get the information. If the information is allegedly with the complainant or respondent, you must ask them for it, tell them that you need it, and let them know if you don't get it, it may affect the outcome. Both sides must have an equal opportunity to present witnesses and evidence. No restrictions on discussing allegations or gathering and presenting evidence, and equal opportunities to have an advisor present during the grievance process. Talk about it. Yes. That is an advisor who can be anybody they choose. So you could, if you allowed one person to have that, one party, you would have to allow the other party to have that. Does that make sense? Although I believe you could restrict it to an advisor for both parties. If you allow anybody else, you have to allow both parties to have that. Does that make sense? So it's equal opportunities to have others present. So the initial steps in your investigation, just remember these things. When you start investigation, and I'm going to record a video just on the investigation portion, on interviewing and things like that. But just as an overview, think about who should be interviewed, what evidence should be gathered, a timeline for completion of all of your steps. If not already completed, whether the allegations require a report to CPS or DHS, what we generally call it here, or law enforcement. Think about those things. Are there going to be any delays or extensions? Temporary delays in the investigation will only be allowed for good cause. If you're going to have a temporary delay, you have to provide written notice to the parties explaining why you're having the delay and how long it's going to be. So one reason for a temporary delay may be that one party is unavailable. Maybe they're out of state for a few days. One reason for a temporary delay could be a law enforcement investigation. However, that's a good point. I think our current COVID circumstances could cause some temporary delays. If somebody is sick, what if they're quarantined? Well, think about it. Maybe you can do the investigation. Maybe you can talk to them by phone. Who knows? But there could be good reasons. It has to be good cause. Law enforcement. A delay for a parallel law enforcement investigation must be reasonably short, preferably no longer than 2 weeks, and only for the time it takes law enforcement to complete necessary interviewing and evidence gathering, not for them to make a decision. When such a delay occurs, the institution must provide written notice to the parties of the delay and the reasons for it. Remember, well, not remember, this is new. Interviews, meetings, and hearings. Anytime you want to interview somebody now, you must provide written notice in advance to the interviewee indicating you want to interview them, the date you want to interview them, the time, the location, the people who will be involved, and the purpose of it. It must be provided far enough in advance to give the parties sufficient time to prepare to participate, a couple of days at least. Probably.
Is that for
So the question is, that is the notice of interview just for the respondent or the complainant, or is it for anybody? It is for the respondent, the complainant, and anybody else, anybody you want to interview. Which is why that document I put on the Title IX forum, which is the notice of the allegations, also has a notice of interview. the same document, so that you can kill two birds with one stone if you want to. Say again? Oh, do you have to let the respondent and complainant know everybody that you're interviewing? They have a right to know who you've spoken to. However, you don't have to let them know prior to the interview. I'll show you when they will get to know here in a minute. Remember, the parties have a right, the respondent and complainant have a right to have an advisor of their choice during the process. You cannot restrict either party's ability to have an advisor present at meetings. The advisor can be anyone chosen by the party. They do not rule out students. Specifically in post-secondary, they say another student is an acceptable advisor. I think that is preposterous. So the question is, if you're a post-secondary institution, can they bring a friend in? Only if that friend is their chosen advisor. Like if they are, in my opinion, now you can allow them to, but in my opinion, you restrict it to one advisor apiece. And their advisor, then they choose one advisor. You're also going to have to determine, you're probably going to have to have, I would strongly think about trying to think, there's going to have to be some way to ensure the advisor understands the extreme confidentiality requirements they're under. Because in my opinion, this is a violation of FERPA. In my opinion, it is a violation of FERPA. Because the respondent, if they choose an advisor, they can waive their own rights to FERPA if they're an adult, and their parents can waive their rights to FERPA if they're not an adult, or if they're K-12 and not an adult. But they can't waive the rights to the complainant's FERPA rights, which they will be obtaining student information about the other party during that interview. I am more than frustrated with OCR's lack of willingness to understand this. To me, it just shows a total lack of understanding about FERPA and a total lack of disregard. But that's Brandon. That's Brandon's getting frustrated. I've been telling K-12 people to be really careful about the friend thing, being the advisor. Be really careful. And to encourage somebody, them getting somebody who actually might be able to help them, like their parent or a guardian or something else, rather than a friend who is not going to be quiet, who just isn't. I'm just telling you, they're not. They're going to tell somebody, and that person's going to tell somebody. Why? Because they're kids. Adults have trouble being quiet. We have trouble being quiet. Kids have more trouble. They don't always understand the consequences. The complainant and it says that you cannot provide any restrictions on the complainant and respondent talking about the case. It does not say you can't put. I don't believe that extends to their advisors. I think you have to put the advisors on notice that they cannot speak about this to other people. Also, you can remind them of the retaliation provisions, that they cannot do anything based on the knowledge they've gained to retaliate against one party or the other. I do think you can have an advisor sign a confidentiality. I just got that question. I do believe you can have an advisor sign a confidentiality. There's no requirement to pay for a party's advisor. However, if you have a hearing, they have to be provided an advisor if they don't already have it. So you may want to think about a staff member who would be a good person to be in there and help them during it. Conduct the investigation in a manner designed to obtain and document all information necessary to determine whether the allegations are true. Evidence gathering, be deliberate about gathering any possible evidence that can help in making a determination. Remember your search rules and your search policies. Now, once you've gone through your investigation and had your interviews, gathered evidence, documented interview conversations, this is the first really big deal in the investigation process. You have to provide the opportunity to inspect. What is this? Prior to the completion of your investigation report, you must provide to both parties, respondent and complainant, an equal opportunity to inspect all evidence directly related to the allegations, even if the institution does not intend to rely on the evidence, and an opportunity to meaningfully respond to the evidence after inspection. The evidence must be provided in electronic form or hard copy prior to the completion of the investigation report. That is in a format that they cannot change. The parties must have at least 10 days. Well, this must be, the parties must have at least 10 days to respond in writing to the evidence. And the investigator must consider their responses and determine whether it should influence their investigation report. Remember also that the same evidence must be made available to both parties for inspection and review for the hearing. And they must have the opportunity to review it. Now, or refer to it. Now, that's your first big deal, the opportunity to inspect. Once you've gathered all the evidence and you're drafting your report, your investigation report, you must provide them both the evidence in electronic or hard copy in a way that it cannot be changed. You don't provide them Word copies. And give them 10 days, it just says 10 days. 10 days to review it and provide written responses if they so choose. So when you provide them the opportunity to inspect the information, you should probably put some type of notice next to it saying this is, in furtherance of our obligation to give you an opportunity to inspect the evidence that will be considered or that has been gathered. And you have 10 days to provide written responses. You may provide them to me in this way by this date. And then you must complete an investigative report. The regulations specifically state that you must create a written investigatory report that fairly summarizes the relevant evidence. I will soon have a model investigation report on the forum. I just have not had time to finish it yet. The report must be, this is the next big part. The report must be submitted to the parties and their advisors at least 10 days prior to any hearing or final decision. And they must be given at least 10 days to review and provide written responses to the final report. once that final report is done, you're doing one of two things. I think for career techs right now, if it's offered on your campus and you do the discipline, you need to just provide hearings for everyone. I know that's not what I had said previously, but I do not believe OCR is going to recognize the difference. And I do not believe the regulations are clear enough to show that there's a difference. I want there to be. I just don't think there is. So a live hearing. The decision maker must permit each party's advisor to ask the other party and any witnesses all relevant questions and follow-up questions, including those challenging credibility during the live hearing. At either party's request, the parties can be in separate rooms with technology that allows them to see and hear each other. Why? At the institution's discretion, any or all parties or witnesses may appear virtually. You must create an audio or audio-visual recording or a transcript of the hearing and make it available to all parties. I have a question that's in the chat that I will get to in just a second. I see that you've asked it. There's not a lot, actually there is quite a bit of stuff in the regulation about live hearings. Going into a live hearing, I'm going to do a separate video for live hearings too. But I also kind of want to look at what some of the national groups are recommending for processes of live hearings before I make them. What I will tell you is that both parties and their advisor must be there. The decision maker presides. They can be in separate rooms at the request of one party or the decision of the institution. They must be given the chance to ask questions of the other party, follow-up questions to the other party, and the advisors asking the questions. If they do not have an advisor, you'll need to appoint one for them for the hearing. And the decision maker will make decisions once they ask the question, whether it's a relevant question that's asked. Now, if you have a hearing, after the hearing, the decision maker finalizes the investigation report, if anything else needs to be added, and issues the written decision, which we'll talk about. If there was no hearing, the decision maker would have had to allow both parties to submit written questions to each other and limited follow-up questions before finalizing. I have a question. How can the control be maintained over the document? That is a fantastic question. That is one of my main concerns. I'm not sure. See, there are major FERPA issues with just letting that information go, in my opinion, when you're talking about the opportunity to inspect the investigation documents. I think the only thing you can do is reiterate a lot how the consequences for releasing this information into the public domain. Possibly also requesting the copies back at the end of the 10 days. Of course, they'll make copies. Again, I think this is a process that just is not, it's not smart. I tell you, it's not. This information is going to get out. However, in my opinion, the most you can do is reiterate in writing constantly the confidential nature of this information. And maybe there's a way to, I'm not very tech savvy, but I know there are ways that you can, require a key to get into a document or something. Maybe you can do that. I would make sure maybe you can do something like that. I don't know though what happens once the individual can't, enters the password and gets into the document. I don't know what happens then. I don't know if they can print it or what. What if documents become published? What becomes a disciplinary issue? It's going to be hard to say that it's going to be hard to say you violated FERPA when the federal government ordered you to do this. Well, they're both the Department of Ed. They're just different. OCR is a agency within the Department of Ed. Family Compliance Office, which enforces FERPA, is an agency within the Department of Ed. So the question was, you have to pick whether you are going to be afraid of OCR or the Department of Education. Well, OCR is part of the department. Entities we're talking about here, whether the Family Policy Compliance Office, which implements FERPA, or OCR, which implements Title IX, they both are part of the Department of Ed. So the Department of Ed is the one that has told you to do this. So they can hardly then find you guilty of a FERPA violation. Now, what you might want to think about doing is redacting student information from what you release and then offering to talk to them about, to talk to them verbally about who you're talking about if they have questions. You can think about doing that. I probably would. Because generally, a lot of times they're just going to know who you're referring to. Or they're going to say, we need to know who the witnesses are. I mean, you can get them on the phone and tell them who that witness is and that witness is. That way, at least it's not something, at least it's not in what you've released in written form. We're all trying to figure out how to do this in the best way possible, and OCR hasn't made it easy. Now, sexual behavior or predisposition. With or without a hearing, all questioning must exclude evidence of the complainant's, the alleged victim, sexual behavior or predisposition, except to prove that someone other than the respondent committed the alleged conduct, and when specific incidents of the reporting party's the complainant's sexual behavior with the respondent are offered to prove consent. So, the only time you talk about their sexual behavior or predisposition, to allow discussion about that, would be to show that the respondent was not the one that committed the act, or to show that this was consensual, or here's evidence that it was consensual. Once the hearing is done, or if it's a situation where you're not having a hearing, the exchange of questions is done, you must submit a final written determination. which must include at a minimum, and these are all on that slide 91, a list of the allegations, a description of the procedural steps taken from the receipt of the formal complaint through the determination, findings of fact supporting the determination, conclusions, and the rationale for the determination regarding each allegation, which should include the disciplinary sanctions imposed and the remedies to be provided, and rights to appeal. I will have a model document for that, because that's a lot. But this must be submitted to both parties. This must be submitted to both parties. Now remember, when you submit determination to the complainant, only provide her, that was, I mean, it may not be a her. You'll only provide the complainant with regard to disciplinary measures instituted. You'll only provide the complainant the specific disciplinary measures taken that also affect the complaint, which means they've been ordered to stay away from you on appeals, etc. If you're suspending somebody for a certain length of time or whatever, you don't provide that. You just say, and other discipline that was, obviously they'll find out when the person's not there. But like if one of the disciplinary measures is that you cannot be in the building when the complainant's in the building, or you cannot be in classes with the complainant or whatever, you can tell them that. That way the complainant can say he's not adhering to the agreement. Appeals. Must provide an, okay, so you can provide appeals for more than this, a reason to appeal for more than this if you want. However, you must provide an appeal under Title IX for at least the following: a procedural irregularity, which means you didn't follow, they're alleging that you didn't follow the grievance process required under Title IX. New evidence that was not reasonably available at the time of the determination was made that could affect the outcome. The Title IX coordinator, investigation, or decision maker had a conflict of interest or bias against one of the parties. You must provide an appeal for at least those three things. Where did I put that list of questions? Training. Oh. Do you keep the document for the questions I just got? I'm going to answer that here in just a minute. The school's obligations for Title IX training, education, and prevention as per the regulations. Title IX coordinators, investigators, and decision makers, and any individual that facilitates an informal resolution process must receive training on the following. The definition of sexual harassment, you've gotten that today. All activities included in the institute programs or activities, we've talked about that. If you need to provide something specific to your team, feel free to do so. How to properly conduct an investigation pursuant to the grievance process listed in the regulation, including appeals and informal resolution processes. We've done most of that today. But I will investigating allegations impartially, including conflicts of interest, etc. I'm making a video on that for you. With regard, I'm also that third part, to make sure it's totally complete, I'm doing just a video based on just the ins and outs of actually interviewing, gathering evidence, etc. The technology that may be used to conduct a live hearing, that's going to be up to you. Whatever technology you use to make sure that people can participate virtually if you do that. Issues of relevance with regard to questions, including being able to determine when questions about the reporting party's sexual predisposition or prior sexual behavior are irrelevant. We talked about how to create a report that fairly summarizes the evidence. That will be part of my investigations video that I'm doing. But we did talk a little bit about what should be in reports. The regulation also requires that all materials used to implement these trainings be made available on your website. Or if you do not maintain a website, which all of you do, I'm sure, upon a request for inspection by the public. What I would do is just under your wherever your Title IX statement is, or your discrimination statement is, or whatever page your Title IX coordinator is listed on, provide a link where they can click on the link and see the different trainings you've done. Retaliation. The new regulation prohibits retaliation for filing complaints or otherwise participating in the process or refusing to participate. It also indicates it is not considered retaliation for an institution to provide disciplinary consequences when an individual makes a materially false statement in bad faith in the course of the grievance proceeding. So yes, people can be disciplined for giving you false information during the investigation. However, you must have evidence that it was false and made in bad faith. In other words, they knew it was false and said it anyway. With regard to record keeping, the new regulation says the following must be created and maintained for 3 years, at least. Investigation documents, including written finding, disciplinary sanctions, and remedies implemented, appeal documents and related results, informal resolution documents, supportive measures implemented. So document the supportive measures you provide to people. Now, let me look through here. Looking at the questions that I was provided, we talked about procedures and permissible bases to appeal. Procedures we really haven't talked about with regard to appeals. I think that's up to you. The main thing is that, number one, and I should have talked to you about this already, your decision maker cannot be the Title IX coordinator and cannot be someone that investigated the case. It must be someone else. The appeal must be to someone who is not the decision maker or the Title IX coordinator or the investigator of the case. Whether you have a panel on your appeals or whether you have one person. Reasons for withdrawal of a formal complaint. They give us specific reasons. I wrote some of them down, but they give us specific reasons for withdrawal. That's right, 106.45B3II. The complainant requests a withdrawal is a reason. The respondent is no longer enrolled, and you determine that there's nothing that can be gained from an investigation if they're no longer enrolled or employed or whatever. Something prevents you from gathering evidence, which is a complainant's refusal to participate, or something like that. Those are reasons that you may, and let me actually look it up real. In the regulation, it is 106.45B3I. Actually, I have, because my life is inundated with Title IX, I have it on my laptop now, the regulations. Let me pull that one up. 106.45B3I.
That's off the top of your head.
Yes. No, so the question is, could the Title IX coordinator withdraw the complaint if the respondent was not participating in the interviews? That'd probably be possibly if the complainant was not participating in the process, not the respondent. Here's the actual language. The recipient may dismiss the formal complaint of any allegations or any allegations therein if at any time during the investigation or hearing the complainant notifies the coordinator in writing that the complainant would like to withdraw the formal complaint. The respondent is no longer enrolled or employed by the recipient, or specific circumstances prevent the recipient from gathering evidence sufficient to reach a determination as to the formal complaint or allegations therein, such as the complainant is refusing to participate and provide information, something like that. If the respondent's refusing to participate, I would not withdraw the complaint just based on that. I would let them know that their failure to participate could affect the outcome. The recipient, let's see. Dismissal is required if the conduct alleged in the formal complaint would not meet the definition of sexual harassment. You really shouldn't open it, but if you do and you get further into it and you realize it wouldn't meet the definition. If it did not occur in the education's program, in the recipient's program or activity, again, if you get into it and you realize you don't have jurisdiction. That's it. So you must dismiss if you don't have jurisdiction because it's not sexual harassment or not in your program or activity. And hopefully you don't open it. But if you get further into it and realize the information you're getting is showing that that's the case. Or you may dismiss for those reasons, those three reasons I spoke about a minute ago. Regarding non-disclosure and investigations, do we interview the claimant and then tell the respondent what the complainant said? Do we interview the respondent and then tell the claimant what the respondent said? Do we interview witnesses and then tell both the claimant and respondent what the witnesses said? Do the respondent and claimant come together for the first time at the hearing, if there is one? All good questions. When you interview, the order of interview is up to you. I generally like complainant, then respondent, then witnesses, or complainant and witnesses and then respondent and witnesses. I like one of those two orders, depending on what works. If you can do it, you know, the circumstances may just be that you can get the other people. You do have to tell them what you do have to tell one party what the other party said or what witnesses said, or they can't respond to it. So yes, you do have to tell them. The respondent and claimant will either first come together in an informal resolution process if you decide to order one, decide to offer one. If you do not offer one, then nothing. And remember, they don't necessarily have to be in the same room. If a post-secondary student allegedly harasses a secondary student, do we have to have a hearing? I think we've really clarified because of what I'm suggesting you do. I am going to make a call to OCR, Kansas City office, which is over Oklahoma, and try to get them to see it my way. Don't you get your hopes up. I think we answered that. Does the school have to offer supportive measures to the respondent? Yes, you do. Remember, you have to offer supportive measures to both parties. It doesn't mean the same supportive measures. And you may not, I don't know what you're going to offer to the respondent. You may have to be creative, and they may not want it. But if you open an investigation, you have to offer supportive measures to both parties. Remember, prior to a formal complaint, you're only offering supportive measures to the complainant. When you make that call and say, here's how you file a formal complaint, we'd like to offer you supportive measures. You're only obligated to provide them to the complainant at that point. However, if you open a complaint after they file a formal investigation, or you decide to file a formal complaint, then you must offer to both parties. Should a report still try to be handled at the lowest level possible? Not anymore. They must go to the Title IX coordinator. They absolutely must. And what you're going to have to do now is have a Title IX coordinator and then specific people who investigate, which might be your assistant campus directors, your campus directors, I don't know. Your Title IX coordinator may also investigate. But it no longer can be the lowest level possible. It must go to the Title IX coordinator so that all these steps can be taken and an investigator can be assigned. And the Title IX coordinator should be there to assist the investigator in any way they want. And also make sure the policies and grievance procedures are being followed, the proper notices are being given, etc. Informal resolutions. I mean, we talked about those. I'm going to do a video on those when we kind of learn more about what those are. I used to do informal mediations when I worked for the Office for Civil Rights, assuming they're going to be almost the same thing. So if I don't hear anything soon, I'm just going to do a video that explains how to do one of those. Are we able to record the training for the oath? That was your question. Yes, you are. When we talk about responsible employees, do I have questions right now? Mm-hmm. Great question. The question is, a student alleges sexual harassment against a staff member, and you determine that it is something that should be opened. Do you follow your staff sexual harassment policy or your Title IX sexual harassment policy? You follow Title IX because it's against a student. If it was one staff against another, I would follow Title VII. But if it's a student making the allegation, I would follow your Title IX policy. Yes, which to me just crazy. Yes, yes. Yes, the question, the point was, then the student is going to be faced with being in a hearing with an employee. Yeah, very possible. And that's just, to me, that's absurd, but that's kind of where we are with these regulations right now. If the presidential election causes a change in administration, do I expect there to be changes? I do. But these change, so that's an if. We don't know what's going to happen. And if there is a change in the administration, these changes were made to the regulations, which means the regulations can only be changed by doing a notice and comment period and then changing the regulation. It takes time. So it's not like they're going to be changed immediately, even if there was a change in administration, which we don't know if it's going to happen or not. So yes, it's, now I will tell you, if you have evidence that an employee is harassing a student, you're going to have to think, you may not have Title IX jurisdiction if it happens at someone's house, not at a school event or anything, but you're darn sure going to have to address it under some other policy. If you did not do it under Title IX? Okay, so let's say. But originally you didn't address it under Title IX, you addressed it just under your staff policy. Okay, so you get notice of an allegation about an employee harassing a student, but you determine that you don't have jurisdiction under Title IX, but you have jurisdiction under your staff policy. What might happen if a Title IX complaint is filed? Well, you will just provide them the information, number one, that shows why you did not have jurisdiction under Title IX and go forward under the Title IX grievance procedures, and that you resolve the matter under your own policies anyway. You see what I'm saying? But you need to document why or why not you have jurisdiction. So if you determined that you didn't have jurisdiction because it wasn't in a place, activity, a place or activity or event that over which the institution had substantial control, then you document that and show OCR. This is why it wasn't done under the grievance process, because we didn't have jurisdiction. So let's say, okay, you did have jurisdiction, but you still went through your staff policy. Oh, good question. So, so you don't have the safe harbor, which means they're going to look at it and determine whether your response was deliberately indifferent. If they determine it was deliberately indifferent, what OCR generally does is they'll either ask you to or say that you violated Title IX, and they'll require you to take certain steps to remedy it. Training, maybe offer something to the student that wasn't offered previously, things of that nature. Their ultimate stick is we can withdraw your federal funding. They've never done that before. Knock on wood. Yeah. No, you don't. No, you don't. Any other questions?
And I apologize to get the sound in the backbeat to stop. I had to turn all my speakers off. So if you are talking, we can't hear you. So please put any questions in the chat box. Thank you. And all these forms that Brandon was mentioned during his presentation, I do have. So if you don't have them and you would like them, let me know. I can email them to you.
And let me also tell you how to get a hold of them too, because I'll be adding more, is go to the OSSBA website. So you've got to be in our system and you have to be tagged as a Title IX person. So if many of you are, if you're not, get a hold of Christy Watson or Kelly Ross or one of them, and they can make sure in our system you're tagged as a Title IX user. And once you are, you go to our website, you click on member portal. If you don't already have you use your email and a password. If you don't already have a password, the original password to get you in is password 123. And then you go to OSSBA forums and go to the Title IX forum. And on that Title IX forum is that's where the documents are. This PowerPoint is just provided. Alan is going to provide it to you.
I emailed the PowerPoint this morning, and I emailed the notes. I emailed these to everybody this morning.
Let's see. At this point, just remember, I'm going to do a video for bias and conflicts of interest. I'm going to do a video based specifically on the nuts and bolts of an investigation. I have an old presentation from a year ago I did on that, but with the new grievance procedures, I want to implement those in. I'm going to a video training on informal resolutions and hearings. Now, there are still some documents I want to put on there, a better model investigation document, a better model final written determination. I don't already have that on, I can't remember. And with career text, just remember under these Title IX regulations, they don't recognize the unique setup of our career techs. Under the Title IX regulations, it's very clear that institutions that offer vocational training that is meant to prepare people for a certificate in a trade is considered a post-secondary institution. Post-secondary institutions are to follow the post-secondary guidelines with regard to notice and with regard to adherence. So, and speaking to people that from Oklahoma Career Tech and getting an idea of the makeup of the services provided, I believe the only time the K-12 rules right now that OCR will consider you to be able to follow the K-12 rules is when the program is offered on campus and the students are all subject to the normal high school disciplinary procedures. I'm going to make a call and send an email to OCR Kansas City to see if I can't get them to be a little bit more flexible with that requirement. Don't hold your breath. I know I'm supposed to be looking at the camera, but I see you all, so I'm looking there, sorry. The link on the website to training, is it the title of the training or does it need to be the actual training material? Oh, good question. It needs to be the training material. So once you provide the link, they have to upload the material to your website. When they click on that link, they have to be able to see the material that you've used for training.
A good example of that is Red River. If you go to their website, scroll down to the bottom, they have their Title IX and 504 coordinator. And underneath that is a little link that says Title IX training. You open that up, it has everything listed. And then you can click on each individual item and it'll bring it up so anybody can view it.
Other questions? Do not hesitate. A lot of you do speak to me just anyway, but don't hesitate to give me a call or send me an email. My email, Brandon C, so BRANDONC @OSSBA.org. Our number is, type it in, our number is 405-528-3571. So either way, get a hold of me if you have questions, and I can help you. People call me. The email, Brandon C @OSSBA.org. People call me every day, basically for questions on Title IX or other things. So don't be afraid to call. Question is, do I think we're going to see more or fewer Title IX complaints now that the new regs are out? I think there are going to be fewer allegations that are investigated under Title IX because a lot of people aren't necessarily going to want to put it in writing and file it for them. It very well could be. Very well could be. And so you may be investigating a lot of these incidents as you were investigating them previously, if they don't file the formal complaint. And even if they do, remember, the days of you trying to determine whether you have jurisdiction over something that happened on a weekend or in the evening at somebody's party or something like that are over. You're not going to be investigating those. The one instance for most a lot of post-secondary schools will be fraternity and sorority. So yeah, that's what I foresee. And then if there is a change of administration in a year, I see another change because that seems to be what people are doing. Okay, well, let's see. I don't think I have any other questions on there right now. You've got my contact info. Give me a call or email me, and Thank you for having me, and I hope it was helpful.
Thank you very much for attending and participating. I greatly appreciate it. Again, if you have any questions, feel free to contact me, and we will do whatever we can to help everybody out, because ultimately we want to keep everybody as safe as we can. All right, thank you very much, and I'll be seeing a bunch of you soon. Thank you, and have a great day. And I'll leave this open for a few more minutes if anybody wants to stay on and ask any more questions. Okay, I'll get you on there. You get, okay. Thank you guys for driving down.
Yeah. That's what I said. It got me out of the office.
Yes.